Welcome dear students. In this lecture, we will be discussing special provisions relating to certain classes. The learning objectives of this lecture are: number 1, to know the meaning of the scheduled tribes and scheduled castes; number 2, to study the constitutional provisions relating to certain classes; number 3, to understand reservation of seats for SC/ST in the Legislative Assembly; number 4, to know the extension of the term reservation; number 5, to ponder upon claims of scheduled castes to services and posts. First, let us start with the introduction. The founding father of the Constitution, Bharat Ratna Dr. B.R. Ambedkar, was aware of the political, social and economic inequalities which existed in the country due to historical reasons. They were aware of the prevailing miserable and appalling conditions of the scheduled tribes and scheduled castes who had remained far behind and segregated from national life. It became imperative, therefore, to adopt a policy of protective discrimination as an equalizer to those who were too weak to compete with the advanced sections of the society in the race of life. The constitutional provisions set forth a program for the reconstruction and transformation of Indian society on a firm commitment to raise the sunken status of the pathetically neglected and disadvantaged sections of our society. The provisions visualized by founding fathers of the Indian Constitution reflected their anxiety and emotion to bring the poor tribals at par with the general social level and into the mainstream of Indian political and socio-economic life. Let's now discuss the meaning of SC and ST. Scheduled tribes is of recent origin, which came into being with the birth of the Republic of India on January 26, 1950. Prior to that, scheduled tribes were variously termed as aboriginals, Adivasis, forest tribes, hill tribes and primitive tribes. The term tribe came to be used in denotation of a particular stage of socio-political evolution of a community of people within a given territory and language area up to 1919. They were included along with various other categories of backward classes under the head of depressed classes, which included A. criminal and wandering tribes, B. aboriginal tribes and C. untouchables. The need for separating aboriginal tribes from depressed classes was badly realized by Indian French Committee in 1919 and consequently tribals were accorded a separate nomenclature. In 1931 census, the term primitive tribes was used to specify the tribal population of India, who were till these termed forest tribes or hill tribes. The 1941 census just mentions tribes, all adjectives for the first time being dropped to qualify the tribes. Today, under the Constitution of India, the tribals are scheduled and are properly termed scheduled tribes. The term scheduled tribes first appeared in the Constitution of India. Article 366, clause 25 defined scheduled tribes as such tribes or tribal communities as are deemed under Article 342 to be scheduled tribes for the purpose of this Constitution. Article 342, which is reproduced below, prescribes procedure to be followed in the matter of specification of scheduled tribes. Section 11 of Constitution First Amendment Act 1951, Section 29 and Schedule of Constitution 7th Amendment Act 1956. Now, scheduled tribes. Article 342, Clause 1. The President may, after consultation with the Governor or Raj Pramukh of a state by public notification, specify the tribes or tribal communities or parts of or groups within tribes or tribal communities which shall, for the purpose of this Constitution, be deemed to be scheduled tribes in relation to that state. Clause 2. Parliament may by law include or exclude from the list of scheduled tribes specified in notification issued under clause 1 any tribe or tribal community or part of or group within any tribe or tribal community, but save a aforesaid notification issued under the said clause shall not be varied by any subsequent notification. Thus, the first specification of scheduled tribes in relation to a particular state or union territory is by a notified order of the President after consultation with the state governments concerned. These orders can be modified subsequently only through an Act of Parliament. These articles also provides for listing of scheduled tribes state or union territory wise and not on all India basis. Now we will understand the process of reservation of seats for SC and ST in the House of the People. The Constitution of India treats the scheduled castes and scheduled tribes in India with special favour and affords them some safeguards. The scheduled castes are the depressed section of the Hindus who have suffered for too long under social handicaps and thus need special protection and help for the amelioration of their social, economic and political condition. The Constitution provides some reservation for the scheduled castes and scheduled tribes in the legislature. Article 330 of the Constitution lays down as clause 1. Seats shall be reserved in the House of People for A. the scheduled castes, B. the scheduled tribes, except the scheduled tribes in the tribal areas of Assam and the scheduled tribes in the autonomous district of Assam. Clause 2. The reservation for Lok Sabha seats for the scheduled castes and scheduled tribes has to be made in each state and union territory on population basis. The number of Lok Sabha seats reserved in a state or union territory for such castes and tribes is to be bear as nearly as possible the same proportion in the total number of seats allotted to that state or union territory in the Lok Sabha as the population of the scheduled castes and the scheduled tribes in the state or union territory bears to that population of that state or union territory. In the case of V.V. Giri versus D.S. Dora, the Supreme Court held that a scheduled tribe candidate can contest an election for both the seats reserved as well as open. At the same time, it was also held that a non-scheduled tribe candidate residing in a constituency for which there is a reserved seat will be unable to contest for election to that seat. It may, however, be noted that elections are to be held on the basis of a single electoral roll and each voter in the reserved constituency is entitled to vote. There is no separate electorate. Example, it is not for the scheduled castes and scheduled tribes only to elect their representatives. The system is that though a person belonging to such castes and tribes is to be elected to voters in the constituency, this has been done with a view to discourage the sharpening of differentiation between the scheduled castes and scheduled tribes from the other people to lead to their gradual integration in the mainstream of the national life. In 1961, Parliament enacted legislation provided for the division of 2 members constituency, and thus a non-scheduled caste person will be debarred from contesting election to a reserved seat even though residing in that constituency. It further held that Section 54 of the Representation of People Act is not opposed to Article 330 of the Constitution when it is admitted that a scheduled tribe candidate could compete for a general seat. Also, a member of the scheduled castes or scheduled tribes is not debarred from contesting any seat other than the reserved one. Now moving to the reservation of seats for SC/ST in the Legislative Assembly. Article 332 of the Constitution deals with the reservation of seats for the scheduled castes and scheduled tribes in the legislative assemblies of the state. The article lays down as number 1. Seats shall be reserved for the scheduled castes and scheduled tribes except the scheduled tribes in the tribal areas of Assam in the Legislative Assembly of every state. Number 2. Seats shall be reserved for the scheduled castes or the scheduled tribes in the Legislative Assembly of Assam. Number 3. The number of seats reserved for the scheduled castes or the scheduled tribes in the Legislative Assembly under Clause 1 shall bear as nearly as may be the same proportion to the total number of seats in the Assembly as the population of the total number of seats in the Assembly as the population to the scheduled castes in the state or of the scheduled tribes in the state or part of the state, as the case may be, in respect of which seats are so reserved bears to the total population of the state. 4. The number of seats reserved for an autonomous district in the Legislative Assembly of the state of Assam shall bear to the total number of seats in the Assembly in proportion not less than the population of the district bears to the total population of the state. 5. The constitution for the seats reserved for any autonomous district of Assam shall not comprise any area outside that district. 6. No person who is not a member of scheduled tribe of any autonomous district of the state of Assam shall be eligible for election to the Legislative Assembly of the state from any constituency of that district. The total number of seats in the legislative assemblies in state and the union territories in the year 1968 to 69 was 3,563, out of which 503 seats were reserved for SCs and 262 for STs. Now we will understand the extension of the term reservation. Article 334 of the Constitution deals with the reservation of seats to scheduled castes and scheduled tribes. Originally, Article 334 provided for the reservation of seats to the scheduled castes and scheduled tribes for a period of 10 years from the date of commencement of the Constitution. But by the Constitution Amendment 1959, the duration was then increased for 10 more years, and by an amendment of the Constitution, the duration of this reservation has been extended for 10 more years until January 25th, 1980. 45th Amendment Act 1980. This amendment has substituted the word 40 for the word 30 in Article 334 of the Constitution. Recently, by a Constitution Amendment Act 2009, the duration of this reservation has been extended for 10 more years. Accordingly, it has submitted the word 70 for the word 60 in Article 334 of the Constitution. The handicaps and disabilities have not yet been removed, and that they need this reservation for some more time so that their condition may be ameliorated and they can match up with the rest of the nation. Thus, we find that the reservation for scheduled castes and scheduled tribe candidates, which was originally to cease after 10 years from 26 January 1950, will now cease after 50 years. Thus, this article has since been amended 6 times, extending the period of 10 years on each occasion. Now, claims of scheduled castes to services and posts. The secularism, egalitarianism, integrity and unity as their basis objectives of the constitutional philosophy could not permit horizon division of the country into backward and non-backward for the sake of job reservations. Article 16 Clause 4 empowers the state to make any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in services under the state. The Government of India's policy has been to make reservation for candidates belonging to scheduled castes and scheduled tribes for posts or services under the central government in accordance with the provision of Article 16 Clause 4 and Article 335 of the Constitution. Article 335 of the Constitution laid down as the claims of the members of the scheduled castes and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in making appointments to services and posts in connection with the affairs of the Union or the state. Various instructions are issued from time to time in implementation of this policy, indicating the reservation for candidates of SC/ST in all vacancies in posts, grades under the central government filled by direct recruitment and subject to certain condition in vacancies filled also by promotion both on the basis of seniority cum fitness and selection. These orders have generally referred to the posts grades under the central government as those belonging to class 1, 2, 3 and 4. The Government of India's intention has always been that the scheme of reservation for SC/ST should embrace all the posts and grades under central government, irrespective of whether they have been classified as class 1, 2, 3 and 4 or not, and never to exclude posts in the industrial establishments, whether classified or not, from the purview of the scheme of reservations. The incumbents of the posts in the industrial establishments, whether classified or not, are also governed usually by the normal service rules and regulations of central government on the same lines as other employees holding posts in classes 1, 2, 3 and 4. The various instructions issued by the Department of Personal and Administrative Reform in regard to reservations for SC/ST therefore must apply mutandis to such posts grades also. Now we will discuss special officers for scheduled castes and scheduled tribes for the enforcement of safeguards. Article 338 lays down that there shall be a special officer for the scheduled castes and scheduled tribes to be appointed by the President. It further lays down it shall be the duty of the special officer to investigate all matters relating to safeguards provided for the scheduled castes and scheduled tribes under this constitution and report to the President upon the working of the safeguards at such interval as the President may direct. And the President shall cause all such reports to be laid before each house of the Parliament. It further adds that references to such other backward classes as the President may, on receipt of the report of the Commission appointed under clause 1 of Article 340 by order, specify and also to the Anglo-Indian community. Article 338 makes provision for appointment of special officer. In accordance with Article 338, the post of special officer was for the very first time filled in UP on 18th November 1950 and designated as Commissioner for Scheduled Castes and Scheduled Tribes. The first commissioner was Shri L. M. Shrikant, who remained in the office till the end of December 1961. Now we will know about the appointment and functions of Commissioner for Scheduled Castes and Scheduled Tribes. Article 338 of the Constitution provides for a special officer for the SC and ST to be appointed by the President, whose duty is to investigate all matters relating to the safeguards provided for the scheduled castes and scheduled tribes under the Constitution, and to report to the President upon the working of those safeguards at such intervals as the President may direct, and present all such reports to be laid before each house of the Parliament. The original Article 338 of the Constitution read as 1. There shall be a special officer for scheduled castes and scheduled tribes to be appointed by the President. 2. It shall be the duty of the special officer to investigate all matters relating to the safeguards provided for the scheduled castes and scheduled tribes under this Constitution, and report to the President upon the working of those safeguards at such intervals as the President may direct, and the President shall cause all such reports to be laid before each house of the Parliament. 3. In this article, references to the scheduled castes and scheduled tribes shall be construed as including references to such other backward classes as the President may, on the receipt of report of the Commission under Clause 1 of the Article 340, by order specified, and also to the Anglo-Indian community. Under Article 339, the President is empowered to appoint at any time and is under an obligation to appoint at the expiry of 10 years from the commencement of the Constitution a commission to report on the administration of scheduled areas and welfare of the scheduled tribes in the states. Article 339 Clause 2 provides that the executive power of the Union extends to give directions to a state as to the drawing up and execution of schemes specified in the direction as essential for the welfare of the SC/ST in the state. Article 340 provides for the appointment of a commission to investigate into the conditions of the backward classes. The commission is to report on the facts found by them to make such recommendations as they think proper. And Article 340 Clause 3 provides, the President shall call a copy of the report so presented together with the memorandum explaining the action taken thereon to be laid before each house of the Parliament. The liaison officers who have been nominated in the ministries etc. for work relating to representation of SC and ST should ensure the extension of necessary assistance to the Commissioner for SC and ST in the investigation of complaints received by the latter in regards to service matters. The next is Commissioner for SC and ST. The special officer mentioned in Article 338 Clause 1 was designated as the Commissioner for Scheduled Castes and Scheduled Tribes by the first President, Dr. Rajendra Prasad. Shri L.M. Shrikant, appointed as the first Commissioner on 18th November 1950, continued till the end of 1961. The organization of the Commissioner for Scheduled Castes and Scheduled Tribes was weakened by the decision of the Government of India in June 1967 to take away all the 17 field officers which functioned as eyes and ears of the Commissioner and regrouping them into 5 zonal offices of backward classes welfare and putting them under the central of newly created post of Director General, Backward Classes Welfare under the Union Department of Social Welfare. This step was detrimental to the interests of scheduled castes and scheduled tribes, as the Commissioner was not left with any independent agency to collect reliable information and assessment of the problems of these disadvantaged groups and the developmental programs undertaken for them. In its first report 1969, the Parliamentary Committee on the Welfare of Scheduled Castes and Scheduled Tribes deplored this action of the government and wanted the hands of the Commissioner strengthened. However, the government did not restore the field organization to the Commissioner for SC and ST, whose effectiveness was thus undermined. Now moving to Commission for SC and ST non-statutory. There was a persistent demand by the SC and ST representatives, particularly the members of the Parliament, that the special officer under Article 338 should be replaced by an effective multi-member commission with increased functions and powers. The Ministry of Home Affairs by resolution number 13013/9/77 SCT1 dated 21/7/1978 decided to set up a commission for scheduled castes and scheduled tribes. The first commission was constituted in August 1978 with Shri Bhola Paswan Shastri as chairman. However, this step was taken without abolishing the office of the special officer for SC and ST. On 3rd August 1978, the government introduced a constitutional amendment in the Lok Sabha to amend Article 338 along with Article 350B. This bill could not be taken up in 1978 winter session of the Parliament. It was brought up again in the Lok Sabha as Constitution 41st Amendment Bill 1979, but could not secure the requisite majority. However, in their keenness to get the bill passed, the government advanced the monsoon session by a week. But before any other business could be taken up, a no confidence motion was moved, leading to the fall of the government. The commission set up by an executive resolution, however, continued to function. It was an unsatisfactory situation with the statutory office of the Special Officer for SC and ST and the non-statutory Commission for SC and ST coexisting, charged with the same functions. After then, Commissioner for SC and ST demitted his office in November 1981 and the post was not filled for more than 4 years. Now we will know about the National Commission for SC and ST, non-statutory. On 1st September 1987, the government decided to demarcate the functions of Special Officer for SC and ST and the Commission for SC and ST. It was decided that only the Commissioner for SC and ST would be submitting the annual reports to the President and the Parliament, and the Commission, which was rechristened as the National Commission for SC and ST, would conduct studies. The Ministry of Welfare passed a notification in 1981 laying down the functions of the National Commission for SC and ST. The first chairman of the commission, Shri Bola Paswan Shastri, was succeeded by Shri K. Raja Malu. Now we will know about the National Commission for SC and ST, statutory. The Constitution's 68th Amendment Bill was passed unanimously by the Lok Sabha on 30th of May 1990 and the Rajya Sabha on 31st May 1990. It received the President's assent on 7th June 1990 and was notified as Constitution 65th Amendment Act 1990 in the official gazette. The chairperson, the vice chairperson and the members of the new Constitutional Commission for SC and ST were to be appointed by the President of India in accordance with the conditions of service and tenure of office as the President might by rule determine. These rules were notified on 3rd November 1990. The Commission was, however, reconstituted in accordance with these rules only on 12th March 1992. Now we will discuss the functions of the Commission. The functions of the Commission have been laid down in clauses 5, 8, 9 and 10 of the amended Article 338 of the Constitution. Now we will discuss these functions briefly. Number 1. Investigation into and monitoring of safeguards provided under the Constitution. The Commission is required to investigate and monitor all matters relating to the safeguard provided for SC and ST under the Constitution or under any other law for the time being in force or under any order of the government, and to evaluate the working of such safeguards. The important constitutional safeguards for SC and ST are mentioned in Articles 46, 17, 23, 24 and 25. A. Directive Principles of State Policy. Article 46 is a comprehensive article comprising both the developmental and regulatory aspects. It reads as, the state shall promote with special care educational and economic interests of the weaker sections of the people, and in particular of the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. B. Social safeguards. According to Article 17, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. There are two important legislations relating to this article, viz. The Protection of Civil Rights Act 1955 and the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989. Article 23 prohibits traffic in human beings and begar and other similar forms of forced labour, and provides that any contravention of this provision shall be an offence punishable in accordance with law. It does not specifically mention SC and ST, but since the majority of bonded labor belongs to SC and ST, this article has a special significance for the SC and ST. In pursuance of this article, there is the Bonded Labor System Abolition Act 1976, and there is a centrally sponsored scheme for identification. Now, let us talk about liberation and rehabilitation of bonded labor. Article 24 provides that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. There are central and state laws to prevent child labor. This article 2 is significant for SC and ST as a substantial portion, if not the majority, of child labor engaged in hazardous employment belong to SC and ST. Article 25 clause 2 subclause B provides that Hindu religious institutions of public character shall be thrown open to all sections and classes of Hindus. This provision is relevant as some sects of Hindus used to claim that only members of the concerned sects had a right to enter their temples. This was only a subterfuge to prevent entry of SC persons in such temples. For the purpose of this provision, the term Hindu includes Sikh, Jain and Buddhist. C. Economic safeguards. The provisions of Article 46, 23 and 24 mentioned also form part of economic safeguard. The specific safeguards for the scheduled tribes are mentioned below. According to Article 244 Clause 1, the provision of the 5th schedule shall apply to the administration and central of scheduled area and scheduled tribes in any other state other than state of Assam, Meghalaya, Mizoram and Tripura. According to section 244 clause 2, the provision of the 6th schedule shall apply to the administration of the tribal areas in the states of Assam, Meghalaya, Mizoram and Tripura. Article 275 clause 1 provides that they shall be paid out of the consolidated funds of India as grants in aid of the revenues of the state such capital and recurring sums as may be necessary to enable that state to meet the costs of such schemes of development as may be undertaken by the state with the approval of the Government of India for the purpose of promoting the welfare of the scheduled tribes in that state or raising the level of administration of the scheduled areas therein to that of the administration of the rest of the areas of that state. A similar provision exists in this article for paying such special grants to the states covered under the 6th schedule out of the Consolidated Fund of India. 5th schedule contains provisions regarding the administration and control of the scheduled areas and scheduled tribes. There are 8 states having scheduled areas, that is Andhra Pradesh, Bihar, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Orissa and Rajasthan. The governors of these states have the power to make regulations for the peace and good government of any scheduled area, particularly for following purposes. Number 1, to prohibit or restrict the transfer of land by or among members of the scheduled tribes in such area. Number 2, to regulate the allotment of land to members of the scheduled tribes in such area. Number 3, to regulate the carrying on of business as money lender by persons who lend money to members of scheduled tribes in such area. 6th schedule contains provisions relating to the administration of tribal areas in the state of Assam, Meghalaya, Mizoram and Tripura. There are autonomous district councils and autonomous regional councils not only administer the various departments and developmental programs, but also have powers to make laws on a variety of subjects, example land, forest, shifting cultivation, village or town administration, including village or town police and public health and sanitation, inheritance of property, marriage, divorce and social customs. D. Educational and cultural safeguards. Article 15 Clause 4 empowers the state to make any provision for the advancement of any socially and educationally backward classes of citizens or for SC and ST. This provision was added through the Constitution First Amendment Act 1951, which amended several articles. This provision has enabled the state to reserve seats for SC and ST in educational institutions, including technical, engineering and medical colleges. In this, as well as in Article 16 Clause 4, the term backward classes is used as a generic term and comprises various categories of backward classes, that is, scheduled castes, scheduled tribes, other backward classes, denotified and nomadic, semi-nomadic communities. Article 29 Clause 1 provides that any section of the citizen residing in the territory of India or any part thereof or having a distinct language, script or culture of its own shall have the right to conserve the same. This article has special significance for all the scheduled tribes. Article 350A provides that it shall be the endeavour of every state, of every local authority within the state to provide adequate facilities for instructions in the mother tongue at the primary stage of education to children belonging to linguistic minority groups, and the President may issue such directions to any state as he considered necessary or proper for securing the provision of such facilities. Most of the tribal communities have their own language or dialects, which usually belong to different family of languages than the one which the state's official language belongs. Various experts, commissions and committees have recommended that instruction should be imparted to the tribal children in their mother tongue in primary schools, at least in classes 1 and 2. E. Political safeguards. Article 164 Clause 1 provides that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, there shall be a minister in charge of the tribal welfare who may in addition be in charge of welfare of scheduled castes and backward classes or any other work. Article 330 provides for reservation of seats for SC and ST in the Lok Sabha, and Article 332 provides for reservation of seats for SC and ST in Vidhan Sabha or legislative assemblies. Article 332 originally laid down that the provision relating to the reservation of seats for SC and ST in the Lok Sabha and state Vidhan Sabhas and the representation of the Anglo-Indian community in the Lok Sabha and state Vidhan Sabhas by nomination would cease to have effect on the expiration of the period of 10 years from the commencement of the Constitution. This article has since been amended 6 times, extending the said period by 10 years on each occasion. Article 371A contains special provision with respect to Nagaland. Article 371B contains special provisions with respect to Assam. Article 371C contains special provisions with respect to Manipur. Article 371D contains special provisions with respect to Sikkim. F. Service safeguards. Article 16 Clause 4 empowers the state to make any provision for the reservation of the appointments in favour of any backward class of citizens, which in the opinion of the state is not adequately represented in services under the state. Article 320 Clause 4 provides that consultation with the UPSC or any state public service commission shall not be required as respects the manner in which any provisions under Article 16 Clause 4 may be made or the manner in which effect may be given to the provisions of Article 335. Let us now talk about the laws for scheduled castes and scheduled tribes. There are a number of laws, both central and state, which provide safeguards for SC and ST. Some of these emanate from the various constitutional provisions. Such laws are: number 1, the Protection of Civil Rights Act 1955. Number 2, Scheduled Castes and Scheduled Tribes, Prevention of Atrocities Act 1989. Number 3, the Bonded Labour System Abolition Act 1976. Number 4, the Child Labour Prohibition and Regulation Act 1986. 5, Acts and regulations enforced in different states to prevent alienation of land belonging to SC and ST. In some states, such provision exists in the Land Revenue Code. 6. Acts in different states for restoration of alienated land to SC and ST. 7. The Forest Conservation Act 1980. The Commission proposes to compile list of all such laws, both central and state, which provide safeguard to SC and ST to protect their interests. Now let us look at the order for scheduled castes and scheduled tribes. Similarly, the Commission proposes to undertake an exercise of listing such executive orders issued by the Government of India or the state government which are not covered by the constitutional safeguards or the laws referred to above, but which provide safeguards to the SC and ST or protect their interests. For instance, in pursuance of the constitutional provisions of services safeguards, the Government of India has issued a large number of orders for reservation of seats for the SC and STs in services and posts, both in recruitment and promotion. Besides, they have issued many orders covering various aspects of SC and ST communities and relating to various sectors. All these orders will have to be compiled in respect of the union and the states. Now let us look into the aspect of inquiry into specific complaints. The Commission is required to inquire into specific complaints with respect to the deprivation of rights and safeguards of SC and ST. In order to enable the Commission to perform this function with manageable limits, the Commission would like to appeal to members of SC and ST that before submitting any specific complaint to the Commission for their redress of their grievances, they should clearly state if, how there have been a violation of their rights and safeguards. A large number of representations are regularly received from SC and ST employees working in the government departments, public sector undertakings and autonomous bodies. Dear students, with this we come to the end of today's lecture on special provisions relating to certain classes. Hope you have understood it well. We shall meet again with new topic. Till then, take care of yourself. Goodbye.